everyone, my name is Pragya Rai Manchi and today I am going to talk about the case problem questions. My two other group members are Prasanna and Payal. And now I am going to talk about the two questions from chapter 2. And the issue in first question is that whether the swimming pool company is liable under the law for the actions on part of Martin. If yes, on what legal basis this would be the case? According to the rule, the doctrine of vicarious liability is applicable in the given case, and an employer may be responsible for the actions of the employees where employee remains primary and employer is secondary. Applying this rule in our case, Martin was employed as the sales manager by the swimming pool company and was entrusted with ample of responsibility. However, he constructed the swimming pool in a negligent manner and misused the funds when he was employed with the company. So according to the rule, the doctrine of vicarious liability, the swimming pool company would be held responsible for the wrongful, negligent and dishonest actions of Martin. Now, I'm going to talk about issue number 2, where the issue is whether the company can claim they are not liable for the actions of Martin as he did not follow the instruction. According to the rule, the employer can claim for some defenses on the negligent acts committed by the employees. However, it depends on the facts of the case. The most common defense for the employer is to present the employee has committed his or her tasks in the negligent and dishonest manner. Another thing they can present is that employee has acted against his scope of practice or disobeyed the instruction. And in applying this rule in my case, he performed the dishonest and negligent actions by the inappropriate construction of swimming pool and improper financial management. However, he committed the wrongful activities while working for the company, but none of his actions were authorized by the company. On the other hand, according to the principle of promissory estoppels, the employer should bear the liability on behalf of the actions of the employee, despite the fraudulent actions were performed without the permission of the company. In conclusion, the swimming pool company is not entitled to claim a defense that Martin acted against the instructions of the company. Thank you so much. Now my other friend will talk about the remaining two questions of the contract law. Thank you.
Hi, my name is Payal Dayal and my student ID number is EMV 22377. Okay, I'm here to talk about on question 1, part C, and the issue raised in this question is that whether Martin is liable to the swimming pool company for his actions, and if yes, then under which legal principles of the liability be imposed. The rules here are the liability may be imposed on business when the workers submit wrongful or dishonest actions or negligent activities inside the course of their work. In such cases, the business or the employer is sued by the third parties to recover the loss. At the point when employees act fraudulently, then they commit breach of contract of the said and the faith. Application in this part of the question is, as in the given scenario, during the sequence of Martin's employment with swimming pool company PT Limited, it is found that Martin has committed wrongful and fraudulent. The company has the right to sue Martin intended for breach of fiduciary duty as well as to recover the loss incurred because of the fraudulent behavior and negligence. So conclusion here in part C would be, all in all, it can be stated that Martin is liable to swimming pool company because of his fraudulent actions. Part B of the question is question A, part B. Question 1, part D is the issue here is that has Martin breached any law while setting up his business? The rules applies here is that a contract of employment incorporates with limitation of work clauses in order to protect the interest of the employers from fraudulent actions. Contract of employment. Application here is that the employment contract on non-competing clauses was not mentioned in the given case. In such conditions, we would choose this case by making suggestions. In the event that the contract of employment between Swimming Pool Organizations Pty Limited also the Martin contained a non-competing clause and carrying a competing business amid the residency of employment is disallowed under the terms of contract. Martin would be liable for. Here, the conclusion is that to sum up, Martin might be considered to have submitted breach of law for having set up his own particular business. Thank you.
I'm Prasanna Acharya, and in this presentation I'm going to talk about the roles and duties of directors along with remedies that come if they don't follow the rules. Without losing any time, let's start with the presentation. In the given question, we have like 5 directors in the company. One is Vesna, one is Sergey, one is Illich, one is Mikhail, and one is Zabaid. And they have like different duties and punishment according to the given scenario in the question. Let's first go into the Vesna's common law duties. So she has the duty to discharge duties in good faith, that is under section 180. According to this rule, the decision should not be at the complete will of the directors. It needs to be done in the interest of shareholders as a whole. And we have one more rule in this for her, and that is power should be exercised properly. That falls under section 181. Now let's go to statutory law duties of Vesna. Under section 191, whenever conflict arises, director needs to notify other directors of material personal interest. Now let's go to Sergey's common law duties. In this scenario, Sergey has duty to apply reasonable care, skill, and diligence in the performance of the company. So that is under section 180, subsection 1. And likewise, in addition, there is another duty, that is she must prevent insolvent trading. That is under section 588G, which means like they should not allow a corporation to trade while insolvent. And Sergey's statutory duties include to apply reasonable care, skill, and diligence, which is also under section 180, and must prevent insolvent trading, that is under section 588G. Now let's go to Illich's common law duties, and she has the duty to properly use their position as well as the information they have obtained. That is under section 182 and 183. And her statutory duties include to properly use her position as well as the information they have obtained. This also falls under sections 182 and 183. Now let's go to Mikhail's common law duties, and according to the scenario given in the question, Mikhail's duty includes to prevent insolvent trading, that is under section 588G, and he should not allow a corporation to trade while insolvent. So yeah, that's the duty of Mikhail's under common law duty. And let's go to the statutory law duties of Mikhail's, and under this duty, statutory duty of preventing insolvent trading. So like mentioned in the previous case of other directors, even in this there's a duty of preventing insolvent trading. This means like this should not allow a corporation to trade while insolvent. Now let's go to the last section, and that is Zabaid's common law duties. And in these duties, no conflict of interest is permitted, which falls under section 191, and directors need to give other directors notice of this interest to avoid a conflict. He also has another duty, and that is to apply reasonable care, skill, and diligence in the performance of the company. That falls under section 181. Now let's go to the last director's statutory duties, and he has the duty to discharge in good faith, just like other directors. He needs to follow the duty. This falls under section 180, And another duty includes power should be exercised properly, that falls under section 181. And last but not the least, duty to apply reasonable care, skill, and diligence in the performance of the company. Uh, Now let's. So we just covered all the duties of director mentioned in the question. Now let's talk about the penalties for breach. So whenever those directors don't perform their duties properly, they need to face some consequences, and they are included over here. And they include accounts of profit, rescission of contract, return of property, constructive trust, injunction. So they are like under common law, they falls under common law duty. Now if we talk about penalties for statutory law, uh, every director has some common punishment, and they include a declaration of contravention, compensation orders, pecuniary penalty orders, disqualification, and injunction. So these are the duties and punishment they need to cover, and yeah, this is what I have covered in my presentation, and I would like to thank you for giving me this opportunity.